Hello, my name is Jeff Boleng. We're here for our fourth roundtable to talk about some of the things we've been doing implementing the recommendations from the Defense Innovation Board's software acquisition and practices study that was published about a year ago now. Today we're going to talk about some of the recommendations in the fourth line of effort. Specifically, we're going to talk about IP and data rights. Try to focus the discussion on IP and data rights centered around software and the digital artifacts associated with software. And so I've got a great panel today. I'll introduce them. Starting over on my far right is Mr. Richard Gray. He's the Deputy Director for Intellectual Property in Acquisition and Sustainment now. Prior to that, he was, he's responsible for coordinating all the DoD-wide policy and guidance for IP and licensing and management of IP. So one of the key people in the new policy updates for how we manage IP. So this is a pleasure. And in his spare time, he's also an adjunct faculty member at GW University School of Law. And then so to my immediate right here is Ms. Carmela Rice. Carmela's been on one of our other panels. She's got a really distinguished background in software development, software engineering, primarily in the air and missile defense space, and has been working in acquisition enablers for the last several months. And I want to say one of your primary claims to fame is sort of authored and architected the software acquisition policy. So, yep, nice work there. And then on my left here is Mr. Rick Tossavainen. I'm sorry. Yeah. Okay. So he's the CEO of Dark Wolf Solutions. I'm happy to have an industry person on this panel, especially because this whole IP and data rights thing it's a two-way street. It's something that we have to agree on and negotiate between government and industry. So it's a good, and in your capacity, one of the things that's notable, you've worked a lot with some of our software development houses and done penetration testing, authored the continuous ATO playbook, correct, and that sort of thing. So yep, this is good. So I want to start, so we've got I'm going to try to direct the questions, sort of industry perspective, sort of program manager perspective and policy, and then IP legal perspective. So I'll start with my program management perspective. And so why do we care? One of the recommendations from the SWAP study was that we should require access to source code, software frameworks, development tool chains with appropriate IP rights for all the DoD specific code. So why do we care? Why would we want access to source code so bad?
There's so many reasons. For one, we can do scans of the code so that we can make sure there are no vulnerabilities in the code. We also want to make sure that our organic software engineers have the subject matter expertise, the domain expertise. They understand how the code is architected. We also have independent verification and validation, our software IV&V teams. They review the code for complexity. They do different dynamic testing and static testing. They also look for architectural problems, design problems. So being able to review the code for security and also quality is very important.
Yeah, I'm glad you hit quality too, because a lot of people think it's only about security scanning, but it's quality and several other things. And also to enable eventual organic maintenance or sustainment too. So yeah, I'm gonna pivot over here. How comfortable, so in your capacity, you do a lot of evaluation for continuous authority to operate, that sort of thing.
Yep.
How important is seeing the source to actually gaining confidence that the code's going to be higher quality code and have less chance of defect, right? Or of security vulnerability? There's no absolutes, obviously. But.
Yeah, so the continuous ATO is something that the Air Force has bought into over the past year and a half, and it's to try to get past the traditional RMF process. And part of this is, it's not just the pen test of the operational code, the stuff that's being deployed to production to find those vulnerabilities of a live system, but also a whole mentality. It's a whole shift from traditional waterfall techniques to a team, a DevSecOps team, where you have the developers, you have the security team, and you have the operations team, all working in concert. And for that to work, it is this entire mindset change where we have to be testing, like Carmela mentioned, the static tests, the dynamic tests of the code as it's being built. Because some of that stuff you're never going to see from a penetration test because it's compiled or it's in some sort of bytecode. We're not going to be able to inspect it like you can as it's going through these CI/CD pipelines where we can hang tools off of this, and they can actually stop the production build if there's a significant enough problem. So it's important to be able to get right down to that source code level. If we want to trust and verify and get to a real continuous ATO where our AOs will feel that they can grant the authority to operate.
Right, and so this is I think it's a pretty significant shift for industry to give us access to source code more often or deliver source code more often, which Richard, here's the opening salvo of some of the definitions that we get stuck in. I believe we definitely need access to source as often as possible, both industry and commercial source, organic source. But access and delivery are different, right? And have different meanings. Can you talk to us?
Sure, yeah, absolutely. I mean, one of the classic discussions that we get into when we're looking at the policy and the regulations and the way they work is that delivery of a product is, if you want to think of it as a legally significant event under the regs. Mm-hmm. It triggers a certain amount of things that happen, like the requirement to assert a restriction if you want to bind the government to less than open use of it. Mm-hmm. You have to market in a certain way if it's non-commercial software. The validation procedure that applies for non-commercial software and data is triggered when that delivery event occurs. And traditionally, we talk about things like if it's not a classic form of delivery, either a hard copy or an electronic copy of a file, if it's simply remote access, a lot of vendors want to say that's not delivery, and therefore I'm not subject to the normal marking requirements, and we're not subject to the normal license rights that we have to negotiate. We can be more free-form in it. But in the end, the beautiful thing is that the way the regs work, most of the standard DFARS clauses and things that are used in the contracts really go more to the license rights that go along with it. Mm-hmm. And there really isn't any formal requirement that what you can and can't call delivery or treat remote access as a contract requirement, for example, that's not delivery in the classic sense. So it's really open for negotiation to whatever makes sense for the parties. And it might make sense for me that remote access to the code for certain limited purposes for a limited amount of time might fully meet my requirement, where in the old days I might have said, well, I need a copy so I can bring it in-house. Mm-hmm. But it's totally up for negotiation, just like the rights are, really. The beautiful thing in the end is the clauses can serve as a safety net, that if you don't negotiate something specialized, there's going to be an allocation of rights that is based on rulemaking and equity. But in the end, the parties are free to negotiate anything they want for delivery and for rights, for the most part.
So one of the things that I've been advocating personally, and I think some of the other people is having joint teams where industry partners and government are working together on, like an agile software development team, a 6 to 10 person team, jointly producing code, jointly producing digital artifacts. In that case, what do you think would be the best way to treat that code? And I guess I'll outline the spectrum is, I guess on one end you've got a specially negotiated license, but it's still the vendor's code until some point well in the future when we actually trigger a delivery clause, if we ever do, and the government people are contributing and they have access to it, but it's still non-delivered, all the way over to the other end that maybe the other end of the spectrum is every time that it gets checked into a source code repository, that constitutes delivery. So I sort of think that is like a range. Where would you recommend, or how would you recommend we work a situation where there's joint teams of contributing? Because how does the ownership accrue there?
Well, one of the fundamental rules that is often misunderstood is that the government, no matter what instrument or mechanism you're using, it is extremely rare that the government would ever seek to take ownership or title, if you will, mm-hmm. to the intellectual property, even if it was created 100% for the government, 100% at government expense. The government takes a license of some scope that depends on whether there's any proprietary, privately funded material, whether the government paid for it, and things like that. In the scenario where you have a government team actually co-contributing or jointly creating, mm-hmm. then that brings in a different rule set because they're actually creating intellectual property, but it's much more restricted for the government because the government employees do not get copyright, for mm-hmm. example, in the work that they do as part of their government employees, or their official duties rather. The only real intellectual property form that springs into effect in that scenario is patenting. So if you're working on something where they say the algorithm or the particular embodiment is patentable, then you have to deal with that separate rule set for the government contributions. But otherwise, for the most part, the contractor retains ownership And it's that contractor's copyright and those allocation of rights that will end up governing how the government gets to use that particular item in the end.
Okay.
And it's open for negotiation. I probably could answer almost every question by saying,
Yeah.
but in the end,
We
the parties can negotiate
anything.
whatever
Yeah.
makes sense.
We can negotiate anything, yeah.
Right.
Okay. So that covers part of that.
Jeff,
Go ahead.
there was one other thing I forgot to mention when you asked why we would want access to source code. Another important reason in our weapon systems is we build simulations around the tactical software so that we can use modeling and simulation to verify performance.
Yeah, absolutely. So in these days of digital twins and actually having model-based engineering, system engineering, it's optimal if as the same code or as close to possible the same code runs in the simulator as is running on the real artifact. So that's a really good point. And we're also, this opens up a whole can of worms about simulation and actually simulating in environments with multiple weapon systems collaborating together, trying to get after the what is the JADC2, the joint command and control between any sensor to any shooter sort of thing. I think we come back to that later. So the term IP, intellectual property, and so I've come to believe this more lately, that the government doesn't want to own industry's intellectual property. We want to encourage them to retain their intellectual property. So, because I mean, it creates a marketplace, a better competition, those sorts of things. How are the terms intellectual property though and proprietary related, or are they the same connotation? Does it matter funding source? Because a lot of times we see source code before delivery and it's labeled, industrial-based company proprietary. Pick your industrial-based company.
Right. I mean, as a recovering lawyer, I think it depends why you're asking. If you ask a specific question, then sometimes it does make a difference. Intellectual property really refers to particular defined legal regimes that allow certain types of protections for certain types of innovations. Mm-hmm. The word proprietary, in its most fundamental sense, really just means ownership of some kind. Okay. So in its basic sense, it can mean any form of intellectual property. But most of the time, in my experience, people use the word proprietary to refer to something more like it's a very restricted licensing regime where the customer is getting a very narrow license, for example, only to use in-house, as opposed to, say, compared to an open source product where it's free use. So it's a proprietary model versus an open model, for example, might be one way that it comes up. And it's often used to refer to a trade secret, that the real restriction here is not to disclose it to the IP owner's competitors and things like that. So a little bit of industry perspective on this one. In the performance of your duties, do you team and partner with government employees?
Yes, we're up at Kessel Run, and actually it's a very integrated team amongst contractors and government employees. Writing code, testing code, basically solutioning together. It is a very cohesive unit up there. And how does Darkwolf, how do you all treat the artifacts, the code, the source code, the digital artifacts that are co-created there? So this is interesting because this recently came up, and my perspective is very informed by industry here. When we go after a new acquisition, typically there's a piece called the past performance piece, and in that you can sometimes have a write-up of where you've done similar work, or the Air Force is really leaning ahead and saying, show us your GitLab repository, show us your code. Like, we want to dig through your code to understand the same types of things Carmela was talking about. Do you write quality code? And we love our relationship up at Kessel Run. We actually couldn't use any of that code we wrote because it was co-created with other contractors and with government employees as a past performance. Which was a unique twist, right? It was like, oh, no one ever kind of thought of that. And so we had to pull code from other areas for this one particular past performance. So, you asked me a little bit about the code when you have this joint creation model. That was the one case where I was like, oh, because there's some really good stuff that's being done up there. That is the cutting edge of Air Force software development right now. Is Kessel Run is one of the software factories that's really leading the pack. So it was unfortunate we couldn't use some of that stuff, but we made it aware, and the government is thinking through it. So we'll see if that can change in the future or how that changes.
Okay. So this leads me to a totally unscripted question, which I just have genuine curiosity about, because that model is not only co-creation by government and industry, but multiple industry partners and government on joint teams. Is there a way to have shared ownership, joint ownership? Is it? We can negotiate anything, right? But how do we do that?
Well, I should have a card printed up. Yes, you negotiate anything you want.
Okay.
Sure, and in fact, I was tempted to ask a question to say, well, why couldn't you reuse that? I mean, if the parties had created it, knowing that this was one of the potential uses that one of the parties wanted to make, then you could have arranged up front that it could be used for any particular purpose down the road.
Yeah, so this was one of those things where, frankly, the Air Force is kind of breaking barriers, trying new acquisition methods, and we're having some super fast acquisition methods. I mean, we're down to 7 to 10 days from RFP comes out to submittal, which is good for a small company in many different ways that we can talk about. But it was one of those things where we reached out to the Kessler Run team, right? And it's not something they've ever thought of before. And so the natural inclination is, I don't know how we get this figured out in 7 to 10 days. But it is something that we've left with them, and we kind of keep checking in, because I think as long as we could properly delineate which parts of that code was ours, or what module was ours, our people created, in other words, or did the bulk of it, then it should be, I would think, fair game to submit as a past performance. This is the kind of quality that we could do for you, Mr. Government Employee at XYZ Software Factory.
Is it possible to retroactively change the licensing of code?
Sure.
Okay.
Yeah.
As long as everybody agrees.
Everybody could, yeah.
Okay.
It might be that he didn't have time to think about something up front, but later on a business opportunity arises, and then the parties would get back together and say, okay, how are we going to do this? Can we, if there's some particular element of the code that one of the contributors considers to be their crown jewel and doesn't want to have offered up in this particular arrangement, we could excise that out. You can think about replacing it with an interface in another module, leaving it open, whatever the scenario is. But the parties could always find some arrangement, business arrangement that makes sense for everybody as we go forward. Yeah. It's always better to do it up front, don't get me wrong.
Right. Yeah, there is that
I'll
old
yank my ex-lawyer card if I don't say, think about it up front, try to resolve things early on.
Right, but never a crystal ball, right?
Right, but
yeah.
you don't have a crystal ball.
Yeah, especially we're kind of in a brave new world trying to do continuous innovation, or continuous integration, continuous delivery of code on very short cycles.
Yes.
So this is a bit of a new world. We don't have as much planning time as we had in the past. Carmela, you've worked in really large code bases on THAAD, on IMD, some of those missile defense projects you've worked. What were did you have a pretty standard set of sort of source code delivery policy and licensing agreement on those, or did it vary pretty broadly?
Actually, all of the programs I've worked on, we had delivery of everything. Source code, build scripts, development environment, automated test, anything that's necessary to recompile and regenerate the executable and run it. It's very important to be able to do that because, again, eventually you want organic software expertise for your system, but you're also able to do little things like spin out little prototyping efforts by doing that. So in our contract, we had a procedural defined that, as required, they would deliver the entire development environment to us.
And how often did you trigger that? Like
Every
per
release.
major release? And
Every
was
release.
that annually, 6 months?
Typically,
Probably different for every program, I'm sure.
Well, for the most recent one, every 3 to 4 months.
That's pretty good. Yeah. Yeah, we're shooting for. I always say I want programs to, at a minimum, start at 3-month deliveries and then work back from there to shorter cycles. So.
And that scenario was in for a developmental project, not as opposed to bringing something from commercial off the shelf? Or?
Correct. That was for government purpose-built software.
So currently the FAR, the Federal Acquisition Regulations, they give us, once we trigger the delivery clause, we get one of 3 sets of rights for the government: unlimited government purpose rights and restricted. Richard, can you? This is sort of a leading question. I apologize. It's been argued to me that that's a pretty coarse cut. If you have the full spectrum of access to source code and rights and licensing, that just having those 3 things is pretty coarse cut. How do you feel? Is there any talk about adding some other eventualities in there?
Yeah, there is. I mean, for example, I think industry tends to look at those three license categories. That unlimited rights, for example, at the one end, is the default license category. And by the way, this is all for non-commercial software.
Right, yeah.
So
yeah.
don't let me stop before
Sure.
we mention that it's
Yeah.
different for commercial.
And I hope to get to talk about some commercial stuff.
We'll,
at the end.
we'll
yeah.
leave that for the next.
Yeah.
But for the non-commercial license categories, if the development costs are paid for 100% by the government, the unlimited rights is the default, which really means unlimited. There's absolutely no restriction on what the government can do. Release it on the internet. Doesn't even have to be government purpose. But government purpose rights is, on one hand, it's pretty close to unlimited rights in the sense that the government can do anything it wants in-house. But it reserves, in that one step, the entire commercial marketplace then is still reserved for the vendor in that scenario. And that's the license that applies if it's any portion of mixed funding. If there's $1 private and 99 government, or vice versa, government purpose rights is the median. And that's really where the chasm is that that's a really broad spectrum of a different funding profile. And then at the other end, if it's completely privately developed, brought in, say, under an independent research and development project or something along those lines, then restricted rights, which really just means mostly government in-house use. But there's a huge chasm for that government purpose rights scenario. And that's usually where, again, mixed, specially negotiated licenses, the ability to do anything flexible is part of the answer. But one of the things that we're looking at, and this is a recommendation that came out of a recent Federal Advisory Committee panel, the Section 813 panel.
Sure, you were a consultant for them, yeah.
Government Industry Advisory Panel looking at intellectual property in DoD. One of the recommendations was to come up with templates that can, for specially negotiated licenses, that can live, it's just really a starting point. Somewhere in between government purpose rights and restricted rights. For example, it's a very easy model to think of. Well, we don't really need to use this throughout the entire federal government. This is really a DoD activity. So how about a template that looks like DoD purpose rights? Or scale it back, Navy, Army purpose rights, component purpose rights, program purpose rights. You can take that model and sort of scale it back to the user community that's really relevant, and that is a sort of quick and dirty way to get to a better starting point to negotiate a specialized license. And so that's what we're looking at, is trying to come up with available templates that are totally voluntary, but make it easier for parties to negotiate something that is a better balance of the interests.
One of the things that struck me when I was reading your bio, you also are a member of, you're part of the FAR regulations team?
Yeah, right.
So is it impossible to change the FAR? It's this big mythical thing. I'm reminded periodically that between the FAR and the DFAR, and also I think the FMR, those three, it's like 14,000 pages of regulation or something like that between those three.
Job security for lawyers.
Right. No, well, is it a changeable thing? I mean, is it something?
Sure.
Yeah. Okay.
Sure.
Yeah.
Yeah. I mean, I chair the committee that works on the DFARs specifically, and DoD has a completely separate regime for the technical data and rights and software. So that's where most of our activity is occurring nowadays. But the FAR, the civilian agencies, have a separate rule that has some similarities, but it's different. But both of them can be changed as things come up. And one of the hallmarks in the DoD regs over the last few years is that the statutes that govern technical data that we sort of adapt and apply to software when it makes sense to do so, those change almost every year. So we're constantly, in fact, there's a lot of change happening in the DFARs. We have, I think, 7 different cases pending right now to change those regs and make them a better equitable balance of industry and government needs.
Okay. That's like, makes my whole morning that we could actually change the regulations. Anyway, so let's talk a little bit about open source. There's the use of open source code in government programs, especially weapon systems, is polarizing. So I'm going to start over here with industry.
Yeah.
What is your view about using open source in government programs, especially weapon systems and things like that, where there's all these questions about the provenance of the code, you know what I mean?
Right.
What are the risks, et cetera?
It's a good question and a good point to bring forward. I remember when I first started in industry working in the federal government, we didn't have access to open source repositories to the extent that we do now. Open source certainly existed, but trying to get it through the firewall, one-way transferred to especially a higher classification system for use was almost impossible. So we would be writing some of the the dumbest things that someone could ever write. Right? It's like I'm writing a new encryption algorithm.
Rewriting quicksort all the time.
Right? Yeah.
Yeah.
I'm like, oh, I got to do the left-hand side, now the right-hand side, right?
Right.
There is no reason for anyone to be writing encryption algorithms anymore. These things have been perfected is the wrong word, but open source, there are open source algorithms that do this as well and far better than a team of 10, 15, 20 developers is going to be able to pull off. And especially some sort of classified environment where you don't have access to some of the research material that's out on the internet. So I am a big proponent of open source software that's in common use, right? It should be something that you can get the source code if you need to. We can run it through the full CI/CD pipeline and do a code quality check. Truth is, someone could sneak something in there, right? It's a vulnerability, a 0-day could be baked into there that we don't pick up on. But we've got to, the part of the RMF is like, it's a risk mitigation, right? Is it better off to go write our own encryption algorithm, or is it better off to download a piece of open source that's in use throughout industry? And by the way, when an issue is found, that CVE is raised immediately and patches are issued. So we can patch just as fast as all the big guys out there are doing it.
We hope we can.
We hope we
patch
can.
just as fast if the mechanisms are in
Yeah.
place. I think the part of our current information assurance community, I think, slows patching down a little bit more than it should because of the way our releases work. But that's a different issue.
Yeah.
A little tech tip for the audience: talk about encryption algorithms. NaCl, SALT. It's like the best open source encryption algorithm out there. Why should we do it differently? They always say the encryption algorithms are perfect. The errors come in the implementation.
Yes.
Right.
Yes,
So,
yes.
and there are also a lot of open source libraries that have had independent audits done. So for certain versions, like a literally line by line independent audit is done for. You're never going to show, short of formal verification, you'll never show it's fully bug free, but at least you'll know what the provenance is. Talking especially about licensing. All source code has licenses, right? It could be even public domain, but all source code has some kind of license attached to it pretty much. Are there barriers for industrial partners leveraging open source? Did they get in a legal weirdness there?
There are legal considerations, in part because of what you guys were just talking about a little bit, which is the open source is a collaborative product in most scenarios where a whole bunch of different vendors or people, individuals, have provided
vendors
code.
and individuals, yeah.
And I know that occasionally when the defense contractor is wanting to use an open source product as a deliverable, one of the things they're concerned about is they don't really know the full pedigree, so to speak, of how that code was developed, and there's a risk that if somebody had lifted some code from in an unauthorized manner and contributed that there could be liability that would attach to that. So it is different. But there's no particular hurdle within the regulations. You have to keep in mind that the regs are sort of split up into, the code is either commercial or non-commercial, just as a definitional sense. And open source is not treated separately or defined as one or the other, but the definition of commercial code is that in most scenarios, what we think of as open source, and again, there is no single definition, right? It's almost always going to qualify as commercial code. And the good news there is that the default, unlike the scheme we talked about at the beginning, where there's these predefined categories that are unique to non-commercial code, on the commercial side, the rule is that the government is generally speaking going to step into the shoes, if you will, of the ordinary commercial customer. Take the same types of deliverables and the same, or access, and the same types of license rights that normally go to a commercial customer. And then of course there's, unless it's inconsistent with federal law and it has to meet the customer's needs, of technical needs. But other than those, it's really starting with the commercial model. And that's not necessarily well understood when people are just thinking about maybe doing business with the government for the first time. They think there's going to be some unique scheme that's going to threaten my IP, and it's not designed to work that way.
Right. There was a fairly well-known case when Sun Microsystems, when they still existed, Sun Microsystems at some point in the late 90s, early 2000s, famously open sourced everything, just flip of a switch. But then they actually ran into some problems because they didn't know the pedigree and the ownership and the legal attachments for all the code that they were depending on. So it took them literally several years to fully legally open source all of that because of a lot of entanglement there. Open source use on your programs, did you guys leverage open source?
Absolutely.
In a lot of ways? Okay.
Absolutely.
Did you have any issues with it?
Originally, I was concerned. This was years ago. Like you said, you don't know what's in the code. You don't know who's contributed to it, and you have to be very judicious in the way that you make the decision to use it. But it worked well for us.
Did you have a formal review process? Did you have external auditors? Did you anything like that?
We did not.
Okay.
The contractor reviewed it and did the assessment on their own.
Okay, yeah. I mean, I would argue there's probably not a commercial software product sold today that doesn't have some open source in it, especially things like OpenSSL and encryption algorithms, because one, they're hard to write, two, they're widely available in the open source world, so yeah. So let's talk a little bit about cloud next. So everybody knows we've got a huge trend towards moving to the cloud, right? This is actually, I think, opening up some use cases that we hadn't thought about before, where traditionally software was developed on a corporate network or turned over to one of our depots, our software depots, to a government network. Now we've got this neat thing where we can have shared spaces in the cloud, and most of these systems where we're doing custom development, we want to do them in impact level 4 or 5 clouds, so that national security systems type things. Is this straining industry's model, doing co-development in the cloud? Have you seen that? I'll start over here with Rick.
Yeah, so for us, a small company doing business in DoD, it's fantastic. We can acquire cloud resources. In many cases, they're almost the exact same cloud resources that are being used on production environments. So it's some version of a cloud service provider, their software. We spin this stuff up, can test on it, and then when we're done, I don't have a bunch of hardware that I've got heating, cooling, whatever.
No capital investment.
Yeah, and the cost is really for what we use it. So you got to be judicious, right? You don't want to spin up every EC2 instance or whatever, but
you can burn a lot of money in the cloud.
Yeah. But it has really been a great equalizer, I think, of the companies in industry, especially between large, medium, and small players. We all have access to the same hardware now, effectively, right? There's hardware at the end of the day in the cloud, and we can all test and basically demonstrate this is what it's going to look like when we move it over to GovCloud or Cloud One, or some of these other instances that are all kind of based off of commercial cloud providers. So
Jedi, would we finally get Jedi?
Yes, Jedi, right, exactly. I heard that's a 4-letter word, though.
It is, in fact, yeah.
Well, I think one of the points that's key, though, in that is the concept of that you mentioned right at the end, which is what happens at the end of that development effort is there has to be some provision to be able to, okay, when the government team walks away, what are they taking with them? Maybe this is back to the access versus delivery concept. And as long as you're thinking about that up front and everybody understands what's going to happen, then you're going to solve the problem. But it's really common in the early days of exploring cloud that at the end of the cloud service, if you will, then the government was unsure what it was going to walk away with, and in some cases felt like it walked away with nothing.
Yeah, no, that makes sense too. And you do have disparity between some of what's available commercially and what's available in the government cloud systems. And also, you got to be careful that you don't become dependent on that specific cloud service provider, right? We can't write to that because then you're stuck with that vendor. And in the case of something like Jedi, there may be a new vendor, and that may be the new preferred vendor, and then you can't move any of that software that you wrote. You can, right? But you don't want to be locked. You got to avoid the lock-in. It's the same story we've been dealing with for 20 years. It's just at a grander scale because you're not talking about specific hardware like Dell versus HP anymore. You are talking of both the virtual machines and then the services that they layer in there, such as the IAM services and their database services. And the more of that stuff you take advantage of, the more you get typically a vendor lock-in situation.
Yeah, so I've come to realize a lot more lately after talking with a lot of program managers that we always have some level of vendor lock.
Yeah.
It's really, as a program manager, I think knowing and understanding what it is and what risk or how hard it is to get out of that if you think you need to, if you ever need to. I mean, we're pretty locked to Microsoft Office. I can't foresee us using something different, but it's a conscious choice I think we made. Well, maybe we didn't. But
It was made for us.
I'll get myself in trouble if I go down that road.
Well, but one of the things that we're always reminding the government teams of is that, the exclusive nature of intellectual property, there's nothing inherently wrong with that. I mean, that's the basis for why we have innovation. So we grant those exclusive rights and intellectual property to encourage people to do smart things and then to make, release them in products that people can use. And so really the term vendor lock, and if that just means sole source or exclusive rights, there's nothing wrong with that. The trick is when you get into it when you didn't mean to,
Right.
when you unintentionally got into it.
Yeah, that was where I was talking
or
about.
a co-contributor
Somehow
somehow ends up having one party taking all the rights, and the code developer doesn't get what he or she thought out of it. That's when it's unexpected is the real problem.
Yeah. So yeah, and as we move to cloud, one of the things I've been a real advocate of is everything is code.
Right.
So infrastructure is code,
Yep.
test scripts is code. So now we've got a proliferation, if we follow that model, proliferation of more source code that we need access to.
Yeah, and Carmela touched upon this earlier. The whole concept of GitOps is really getting toward what she spoke about, these 3-month release cycles, where if you have everything as code, if it's all in your version control system, ideally, really you're just moving that, and a press of a button, it generates your infrastructure, generates your platform, spins up your services, generates your
Deploys the
software
applications
composite,
and everything,
deploys
yeah.
it.
And then tests it.
It's right.
And monitors it and everything.
Yeah, it's just snap your fingers. There we go. But it's Nirvana is still out there. We hope to get there one day. But I do hope that it is, because what you were talking about, that's actually very difficult to do a full release every 3 months of your development environment. Like everything you change there, right? Everything that changed on your production servers, especially before this whole concept of infrastructure as code, before some of these tools like Chef, Puppet, Terraform. Like that's incredibly difficult. So I think we're getting tools now that make that easier, and that's good for the government. It's good for industry, because you don't want to keep, like we said earlier, you don't want to keep a bunch of this aging hardware around. You want to be able to have everything packaged in software and then generate the hardware configuration on the fly.
So there's a program I work on that to build one of the servers that gets deployed with a unit is literally 800 hours. It's not a serial process. They do a lot of things in parallel, but to layer in all of the things that they've layered in and do the manual installs. Oh yeah, good grief is right. Yeah. So actually, I don't know, hopefully this will be the first time the audience has heard the term GitOps. You brought up GitOps.
Yep.
Everybody asked me, so first was Agile, then DevOps, and then DevSecOps. Everybody's asking me, what's next?
Right.
Well, I think it's GitOps, right? So everything is code, so yeah.
Everything is code, yeah. It's Nick Shalane is popularizing it in the Air Force, and
industry's there in some cases,
there
yeah.
in some cases, so it's a good direction.
Okay, let's talk about OTAs, other transactional authorities. So first I got to verify this. OTAs are exempt from FAR and DFAR.
That's right, correct.
So to me that's like perilous waters to tread in, right? Because I mean the FAR and the DFAR are flexible and they provide you a lot of guardrails.
Right.
So if we do, there's been broad use of OTAs, other transactional authorities, for software development. What's some advice you would give to people that want to use an OTA to?
I think that
Because you don't have any guardrails.
not having the guardrails feels really flexible, but what that means is you might say you're starting with a blank piece of paper, and so if you're doing development that's too quick and you're not thinking about the long-term needs, like, hey, if we're teaming up on this, how are we going to collaborate? Who gets to use this for bidding on a contract in the upcoming future? If you're not thinking about those kinds of things, then when you transition to the next business environment, that's when you're going to run into the issues. And so the beautiful thing is you have the opportunity to negotiate for almost any solution that makes sense for the parties. And that's the good news of not being constrained by, say, a minimum license that the government can't go below unless you get a deviation through the, the OSD office or something like that. So it's very flexible, but it does mean that you really have to think about what's going to happen and try to capture it in some way that makes sense in the agreement.
Fan? Are you a fan? Not a fan?
I am.
Okay.
I am a fan.
Yeah. The Air Force is a big fan of OTAs lately.
Yeah, we actually have one supporting U.S. Stratcom, and what works well for us is the whole MVP concept. So it's a short pop. I think it was a year and a half, and there were some defined minimum viable products that the Air Force wanted to get to. And for us, the OTA was just fast to get on contract, very, very minimal response needed for this. Now, I know you can do that with the FAR too, but in this case, it was just a very flexible agreement. Now, it does get hard when you get towards the end of that pop, is typically they want to, you've gotten beyond the MVP stage, so we've got to go with a more traditional, should we say, structure. I mean, OTAs I know have been around since probably the 60s with NASA, but
they're in vogue now.
They're in vogue. Now. Yeah, they're hot. So it's been a good vehicle from my perspective on industry side too, particularly in the MVP type of area.
So one of the things that I've been remiss about is we've had a lot of focus with the software study on helping the industrial base and the government produce better code more quickly, higher quality, et cetera. But I've been guilty of somewhat ignoring commercial code, and I've been hearing a lot of demand signal from people lately that, why are you so worried about writing software when we can't even buy commercial products easily? So you basically COTS software. So let's pivot for a little bit and talk about COTS a little bit. So one of the questions I have is, what are a few examples of commercial license terms that the government cannot accept?
Probably the number one thing that has gotten most visibility over the years is the idea of an open-ended indemnity provision. That the government, if something goes wrong, the government is required to indemnify the vendor from something that happens. And the government can't agree to a term like that because it violates the Anti-Deficiency Act. And that's just a classic example. Now in the regulations, we've tried to fix that. There's actually a clause that you can insert in almost every instrument that just says, even if it says that, you aren't really agreeing to it and it's not binding on the government, and it's sort of read out of the contract. But there are, one of the things you keep in mind is that for the commercial licenses, those license agreements are, for the most part, the contract that the parties are using to deal with the entire business arrangement. So, but when you think of a license within the acquisition regulations, the license is the part of the contract that just deals with the government's rights to use, modify, perform, release, disclose, et cetera, et cetera. So you end up getting, in a commercial license, warranty provisions and dispute provisions and choice of law, venue, remedies, things like that, which really are not part of the IP license in the government contract. And so those warranty provisions might conflict, or the choice of law might conflict with something else that's in the federal contract. And those types of things are pretty common. Most of the time, as long as you can get to the negotiating table, those are relatively easy to negotiate out, because the vendors understand the federal government has special rules and you can't agree to a state law jurisdiction, things like that.
Oh, sure.
But the problem is not being able to get to the negotiating table.
Do we have trouble? I mean, is it common that a typical license agreement on a piece of COTS software would assert something that we can't agree to? Is it fairly common?
Yes.
It is common.
Yes.
Okay. Because one of the things I've learned more about the Enterprise Software Initiative, the ESI, which is I thought it was just a centralized way to pool our purchasing power, but it's also really about negotiating the proper licenses for commonly used software as well.
That's right.
Okay.
Yeah, in a scenario like that, again, in that scenario, the government and the vendors have come to the negotiating table and said, here's a gigantic instrument that we'll set up where people can come, makes it easier for the government customers to come buy it, but you have to deal with those issues in that scenario to read those terms out. But it's, as long as you're at the negotiating table, it's not hard to come up with solutions for that.
Okay. Okay, one of our couple more topics here. Software as a service. So things like Workday or Concur, the travel software, those kinds of things. the commercial world has very much trended towards software as a service. Essentially, not even paying for development, not even buying a license, just buying, or sorry, not buying a version, but buying the right to. It's an access right, I think, right? Is this? I'm told this is hard for us to do in DoD, to buy software as a service, that the contracting officers frown on it. Have you had that experience at all?
I've actually never wanted to use software as a service.
Oh, okay.
Because like you said,
you've done a lot of weapon system development, so we wouldn't normally do it there. Yeah. Oh, you do pay your subscription fee, so your missile's not going to work this month.
Right, exactly.
Okay, yeah, that's a bad example for the person that's done a lot of missile defense and weapon system stuff. So, Richard, have you seen this trend, or seen contracting officers struggle with software as a service?
I have, and it actually almost goes to, as you were introducing the question, when you said you don't get a license, and that's kind of the issue, is that it's not classic. It's maybe back to the access versus delivery, and it's not the classic form of a license. But if the government is if the customer, any customer, is going to have the ability to use the product, regardless of how they're getting access to it, whether it's a local copy or remote or whatever, there is an authorized set of things you're allowed to do. Mm-hmm. Can you modify it? Can you copy it? Can you distribute it? And so in the end, I would say that is a license. You might not want to call it a license because the terminology raises issues with the vendor base or something. But in the end, the owner of the product or service is providing authorization for the customer to use that product in a certain way, and that really is, in my vernacular, it is a license. But it's really just part of a contract term as well. So we need to be flexible for how we acquire this stuff. And in the end, there's sort of an issue that people think that if it's being acquired as a service, then you're not subject to any of the normal rules. And that's not necessarily true. But again, I'll keep making another plug for the idea that with no matter which rule set you might be under, whether it's commercial, non-commercial, even if you're going to tech data versus software, the beautiful thing in the end is the parties, once you're in that framework, you can still negotiate whatever makes sense. Let's talk about how the customer is going to get access to it, whether they're going to use it, what they want to be able to do, and what happens at the end of the contract. Who walks away with what at the end? And if you can solve those elements of the business deal, then get it in the contract one way or another, where you want to call it an H clause or a license or an attachment or whatever, doesn't matter to me. Just get it in there so the parties understand what the benefit of the bargain that they're making, and let the lawyers can help us figure out what to call it when it's in the contract.
Yeah, so like when I sign up for something as a personal use, G Suite or Gmail or something like that, I know I clicked through some pages that had a bunch of stuff on it, so I know I agreed to something. I don't know what it was, but
Here we got to slide all the way down to hit the agree button,
right.
It's like, just let me hit it now. I'm not going to read this anyway. I'm just going to pull the slider down.
Right. So what we talked last week, I think, about this in prep. One of the difficulties with software as a service is, at the end of the day, at the termination of the relationship between the government and the service provider, the government doesn't necessarily walk away with anything. Is that problematic? If we pay for access of a software product that's delivered through the cloud, that's online, I mean, hopefully we negotiate so that we can get our data out if we leave the service. But if we terminate the service, we don't have anything. We don't have anything. Is that okay?
If that's the benefit of the bargain, then I think the answer is it's fine.
Yeah. Okay.
If you knew that's what you were doing, like when I renew my, cloud-based word processing tool at home.
Right.
I know at the end of that subscription, when I walk away, I'm done. Right. I don't have anything else, and that's okay. If you are contributing to tailor the software in some particular way, that's when the model starts to change a little bit.
Oh, sure.
Right, and then you start thinking, well, this is I didn't just take this off the shelf like every other customer. We did something special here, and I paid some additional premium to do some additional work, and that's where things start getting different.
Well, and we all know the government's always a unique snowflake.
Right.
So they always have
Just
to
like everybody
customize
else.
something. Yeah.
Well, I think there's another concern. You mentioned getting the data out. If there are no other tools available that will allow you to read the data or process the data, then that could be problematic. So, for example, if you used Microsoft Word and you got your data, but there's no other word processor out there that's capable of reading that data, so now you're no longer able to use it. So we do need to make sure we're thinking about whether or not there's some tool or some mechanism to operate on that data once your license
Make sure
expires.
it's useful afterwards if we want it to be useful. Yeah,
Right.
yeah. So there's a push in the current administration. I think there's always been a push, but the current administration especially to emphasize helping the industrial base build systems so that they're sort of pre-ready for foreign military sales. Does this get massively more complicated when you talk about foreign military sales, or is that really not a distinction we have to worry about? Like if I'm a program manager and I'm negotiating rights to something, but I know that we eventually want to enable foreign military sales, does this complicate the waters?
This is
my extra credit question.
Because
question.
the foreign government or the foreign customer is not part of the U.S. government. So
right,
if you
totally
were
different set of laws, right?
If you were negotiating a license that only allowed the U.S. government to do certain things, then you'd run into a problem when you tried to transfer it. Mm-hmm. But transferring things to a foreign government is included, for example, in the government purpose rights license that we mentioned earlier. And again, you can, as long as you can try to plan for what you're going to do down the road, you can always incorporate whatever the appropriate license agreements are. So you do have to think about it, but I want to say that for everything, right?
Oh, absolutely.
You need to think about who's developing, what the return on investment is, and what happens at the end of the relationship. Who walks away with what? Mm-hmm. That has to be something you're thinking about up front. And as long as you're doing that, get it on paper. Lawyers will help you figure out what to call it, but you got to make the business deal. You can't just use the idea of speed to not think about something and kick it down the road, because it's going to come back at some point.
Okay,
so and you also have to make sure you understand which parts of the code need to be protected. So in some cases, there's some code that we won't release. So we have to be very clear as we're developing the code, which pieces of code are releasable and which ones aren't, even as an executable.
Oh, sure. Like releasable to whichever foreign partner we're
exactly.
Selling or providing the thing to. Okay, so that was my extra credit question. I want to ask the last question to each of you in turn, but I'm going to start over here.
I get to make the first mistake.
The question really is, how does the program manager get help with all of this? Where do they go for help? Where do you go for help? Do you have? You probably have legal counsel on staff, or you're a pretty small company, though, right?
Yeah. We're about 100 people. We actually did recently hire someone who used to be a CO in the federal government. She now helps us with contracts, with proposals, and that perspective has been very helpful. Like over the years, I have picked up a few things by reading through the various FAR clauses we get in every contract, right? But do I intrinsically understand them all? No. So as we grow, we know that to continue doing business with the federal government, we really had to bring some of that talent in-house to up our game. Right?
So as a company, you hired an experienced contracting officer to help you with that. Okay.
Yeah, and she's been fantastic actually. So it's been a great move for us, and it's one of those things where you thought, what the heck did we do for the past?
Yeah, what are we doing all along? Right. Yeah, I remember when I first took the job I'm in now, I'm like, I work in acquisition now. I'm going to go read the FAR and the DFAR.
Right.
I didn't get very far.
Sorry, Rich.
I got to tell you, I've read big sections of stuff that was relevant to me. So I've read way bigger chunks of it than I ever thought I would.
Yeah,
the first day I tried to read the whole thing, then I realized how big it was. So,
yeah.
Okay. So on your programs, where did you guys get help?
Contracting officers.
Contracting officers.
They have a lot of knowledge, and in my experience, they had a lot of knowledge, and where they didn't, they would bring in legal.
Okay. I might have a follow-up question, but go ahead.
Well, one of the new answers that we can give nowadays is, and in fact, the office that I work with now
is IP Cadre?
IP Cadre. It's a brand new office. It's required by law, and it's designed to be a small team, a cross-functional team of experts: engineering, logistics, program management, contracts, law, regulation, all of that. At a very small office at the OSD level that coordinates with offices in the military departments to be able to provide a small group of IP experts with all those cross-functional scenarios and go out and help programs be able to solve their IP problems. And another huge element is being able to reach out and be a resource for industry. As you're engaging, and if you're not sure how to engage with the department, where do you go for business opportunities? Or frankly, if something seems like it's not working out effectively, this is an opportunity where for a small group of experts to figure out how can we be creative and what are the options to be able to help bring these parties together to do a business deal that makes sense. And so we're just standing that up now, so that'll be available as we get staffed up. But another thing and in fact, it just happened last week, is the Defense Acquisition University just stood up an intellectual property and data rights community of practice as a website that's available publicly, and it's intended to be a one-stop shop for any issue that you have, resources that you're looking at, points of contact in DoD organizations. This is the spot that you would go to be able to find that information and get some assistance. Brand new.
So I heard something I didn't know before. To clarify, your shop is also for industry to contact, not just government programs.
Yes, that's
Okay.
right.
Okay, so I think that's really important.
Yeah,
Let's not
one
forget.
of the job functions within our office is going to be industry and community and public outreach. Really, that'll be something that portal, if you want to think of it that way, is not set up yet, but that'll be one of the functions that we offer.
That's excellent. Excellent. So you need, like the contingency lawyers that advertise on nighttime TV, you need a great 800 number.
We might have to advertise.
1-800 get
Yeah,
IP help
that's
or
right.
something. Yeah. We could do some late night commercials. Hi, I'm Richard Gray. You have IP trouble?
Do you have IP problems? Call me at 1-800.
Okay. Parting thoughts from anybody before we wrap things up? I'll start over. Any parting thoughts on access to source code, IP data rights?
I mean, it's, for me, just looking through the TLDR of this book is fascinating. That I think we're moving in the right direction. I love that government's thinking about this. We have what's called the Small Business Innovation Research, and as part of that contract, we actually get to maintain all the IP rights and can sell it commercially. So the government is doing the types of things that are exciting to us as a business, where we can have IP that we sell to the government, and then as part of what we learn working with the government, we can take that and sell that commercially. So it's a lot of great things that are going on here. You just got to be patient, but actually things are accelerating, and it's a good time to be in federal government.
Nice. One of the things that I think doesn't get said often enough is part of the purpose of some of the FAR and DFAR clauses is to actually nurture U.S. indigenous industrial-based companies and help develop those kinds of things. So it's an important part where it's not just about the government owning all their rights. You know what I mean? It's also about the government making U.S. industry stronger too. So, Carmela, any parting thoughts?
Yeah, I think it's very important for DoD to take delivery of source code whenever possible. Having said
Access to or delivery?
delivery.
Okay. You're on the record. I agree with you, actually. I'm in full agreement. I like the delivery side.
I do, because I think it's very important for us to have that organic capability. Having said that, I don't think we should discourage innovation. So if there are small companies out there that are really innovating, the key for those companies is to make sure that they provide the product in a way that can be inserted into other products, and we can protect that IP. Some of our previous programs, we had companies that had proprietary pieces, and it had a defined interface that allowed us to interact with it without having to crack open the black box. So if companies...
And that still worked okay?
Absolutely.
Yeah.
Absolutely. So we knew what the black box was, we knew what we needed to put in, what we needed to come out. And so as long as those companies are creating those interfaces such that they can plug in, then they can innovate, and then we don't have to take delivery of their proprietary software.
We almost made the whole panel without saying the word AI or ML, right? So, but in a lot of cases, that's where those black boxes happen.
Right.
Is those trained neural nets or something like that even if we crack it open, we don't know what the heck the thing's doing. So treating that as a modular thing is important. So.
I thought you were going to get to say that we got through the whole thing and didn't say MOSA.
MOSA. I was thinking MOSA.
I'm going to be in trouble for saying MOSA in the last 5 minutes of the panel.
Yeah.
But that is something I think is really important, is that using a modular approach is one of the just structural ways that when you're engaging with these discussions, it recognizes that there are going to be contributions from different vendors that have different rights, and people want to restrict things in a certain way, and it allows the customer to be able to have access to the technology without needing to get inside the black box, and it allows multiple proprietary modules to collaborate together, and it fits in, I can't say seamlessly, but it fits. That's a really good fit of an engineering approach and a business approach that fits in well with the way the regulations work already. So if you start with that modular concept, you're already going to be in a good footing to deal with this different rights and different parties.
Yeah. Okay. So thanks again to everybody for participating. I had a good time. I learned a lot, as I always do. So thank you.
Thank you.
Thanks, Jeff.